this bill be agreed to in principle. Ms Davidson.
Mr Assistant Speaker, I'm relieved to speak in support of this bill. We know victim survivors have had to wait too long for this bill. They, along with academics and community sector experts, report after report, inquiry after inquiry, told us as lawmakers that there are things we can do to address sexual violence in this country. And I know this because I was one of them listening to victim survivors share their story, trying to connect them with the support they needed, organising protests, gathering the evidence and the data, and trying to tell the story of the systemic change that we needed to the people who had the power to act on it. Now, it's all well and good for lawmakers to attend rallies and protests, but we hold the power in this place to change outcomes. And it shouldn't have taken this long to use that power to create change. But now that we're here, I'm relieved to be working with an Attorney-General who is getting it done and doing it the right way. With these legislative reforms, the ACT government draws a line in the sand. In responding to the recommendations made in the Sexual Assault Prevention and Response Steering Committee's 2021 report, the SAPA report, we're telling Canberrans and the whole country enough. Listen to the voices of victim survivors, and if you have the power to make change, do it now. As a result of the brave contributions of everyone involved in the SAPA report, with heartfelt gratitude to all those over the years who've made similar contributions to other reports, you have been heard. Thank you. This bill contains 6 legislative amendments that would not be here in this place without you. People who experience sexual violence often also experience other forms of violence in a domestic and family setting, and that's why we're moving to make evidence of prior family violence admissible in sexual offence proceedings. This will assist our courts and juries to understand patterns of behaviour and to help overcome false impressions that an incident may have occurred in isolation when there could be relevant information. Principles in common law permit the admissibility of evidence of uncharged acts of family violence as context evidence. We believe if this evidence is relevant, it should be presented. This amendment will send a message to victim survivors navigating the judicial system. Your experience matters and your story will be heard. Secondly, this bill clarifies that a person who's intoxicated through self-induced intoxication is to be treated as if they were sober in determining the fault element of a sexual offence consent provision. We know that drug and alcohol use are risk factors that increase the likelihood of sexual assaults. Intoxication is not an excuse or a defence. You might make the choice to take drugs or alcohol, but if your choice leads you to cause harm to someone else, you should be held to account for those actions, just as you would have if you were sober. Alcohol-fuelled violence has terrified this country ever since the invasion of this land. Australian drinking culture shouldn't be synonymous with rape culture. It's well past time we took a look in the mirror. Self-induced intoxication is never an excuse for violence. The bill introduces an amendment to remove the presumption of bail that applies to a person charged with sexual intercourse with a young person under the age of 16 years, sexual intercourse with a young person under special care, or persistent sexual abuse of a child or young person under special care. This amendment brings these offences in line with other equally serious sexual offences in the Crimes Act to which the presumption for bail does not apply. The bill also introduces 2 new special interim order schemes. The amendment ensures personal protection orders and workplace protection orders can remain in force for as long as there are outstanding related criminal charges. This amendment prioritises safety and will improve court efficiency. The bill will omit Section 80D of the Evidence Act 1991 to dispel any misconceptions about the complainant's evidence and consent, and it allows the trial judge to give appropriate directions to the jury. Amendments to the Crimes Act are life-altering. Any unintended consequences should be quickly addressed to keep in line with the intent behind the amendments. The recent introduction of a positive consent model in our laws require the substitution of the term sexual touching with an act of indecency in the definition of sexual act to remedy an unintended consequence. This further clarifies the principle that consent to a sexual act is informed agreement that must be freely and voluntarily given and communicated by saying or doing something. Informed, clear, enthusiastic, affirmative consent. It's that simple. Now, in commending this bill to the Assembly, I remind the members of this place that what we do here does reverberate around the country. Sexual and family violence isn't an isolated issue. Sexual and family violence isn't a new issue. Sexual and family violence isn't inevitable. Enough. Mr Assistant Speaker, I commend this bill to the Assembly and I thank the Attorney-General for his work.